Deal, y'all. Rich Trapper tapping in TNN Trap News Network early on a Monday morning. It's 9:15 in Atlanta. It's 6:15 in the beautiful city of Los Angeles. We outside giving y'all this good news you use. This good knowledge. You ain't finna get nobody's college, big dog. Hit that like, hit that comment, hit that good subscribe button. Everything we got going on here at TNN Trap News Network. Make sure you get into that news you can use. That good knowledge. You can't get nobody's college, big dog. Make sure you. Y'all get into the like, the comments, subscribe, get into the content, all that wooty bam. You feel me? We here at TNN Trap News Network. Good news you can use. We finna get knowledge. You ain't finna get in college. We finna get into the 20,000 wiretaps have just been released on Big U. So this is Barnacle's work. Shout out to good Cedric Nashington of Nashingtons. Cedric Nashington. Ceddy Nash is giving us good content. Make sure you like, comment, subscribe, and everything he got going on. Give him a like, show him some love. I just did. Make sure you tap in with that tap in. We finna get into it. Let's go.
Government has produced over 60 gigabytes of discovery to the defense, including law enforcement reports, search warrants, and returns, criminal history documents, recordings, and photographs. The government is in the process of producing over 20,000 intercepted audio calls, as well as numerous surreptitious audio and video recordings. Yeah, based on that, a lot of people are saying that Big U is DONE. I'm going to give y'all the paperwork first, and then I'll give y'all what's going on in my opinion.
It sounds like they trying to bury that man.
Let's go. All right, so let's get to it. Here you go. United States District Court for the Central District of California, United States of America, plaintiff versus Eugene Henley Jr. And this is for a stipulation regarding requests for continuance of trial date and findings of excludable time periods pursuant to speedy trial. The indictment date, March 26, 2025. Current conference date, that's May 9, 2025. Current trial dates, May 19, 2025. Or May 20th, 2025, current STA last days. Now, there's a couple of things that pops up for STA as far as the current last days, and that just means basically it's a complex case. So that's really what we're going with, is that it just means very complex. Like, it just, the agreement of the individuals where the disputes are settled in form of laws, meaning this is basically when our times of dispute and everything goes, basically. So that's that. Proposed conference date, now that's on April 24th, 2026. Proposed trial date is May 4th, 2026. Proposed STA last days, this is where it gets real tricky. May 19, 2026 and May 29, 2026. So here we go. Let's just get into it. Plaintiff, United States of America, by and through its counsel of record, the United States Attorney for the Central District of California, and Assistant United States Attorneys Kevin and Jenna, and defendants Sylvester, Mark, Tremaine, Armani, Frederick, and Tiffany, and defendants both individually and by and through their counsel of record, Scott, Kristen, Richard, Scott, Kristen, Michael, John, Carlos, and Kenneth, respectively, hereby stipulate as follows. The indictment in this case was filed on March 26, 2025. Defendants Robinson, Martin, I do not know how to say this person's name, so I'll try. I don't know, cuz. Yeah, we just not gonna do all that. Robinson, Martin, Blanton, and Hines first appeared before a judicial officer of this court in which the charges in this case were pending on March 19, 2025. The Speedy Trial Act, 18 U.S.C. 3161, originally required that the trial commence on or before June 4th, 2025. As to those defendants, Defendant Henley first appeared before a judicial officer of the court in which the charges in this case were pending on March 20th, 2025. The Speedy Trial Act thus originally required that the trial commence on or before June 4th, 2025. As to that defendant, Defendant Williams, that's Luce Cannon, first appeared before a judicial officer of the court in which the charges in this case were pending on April 4th, 2025. And the Speedy Trial Act thus originally required that trial commence on or before June 13, 2025. As to that defendant, on April 4th, 2025, the court set a trial date of March 19, 2025, and a pre-trial conference for May 9, 2025. As to defendant Williams, on April 8th and 14th, 2025, the court set a trial date of May 20th, 2025. And a pre-trial conference for May 9, 2025 for all other defendants. That's interesting. So basically, what they're saying is that, yeah, we wanted to get their stuff done on the 20th, and then everybody else's was going to go on May 9th. So get them all done, get them taken care of, and then we're going to come for Big U and for loose cannon. That's crazy. Defendants Henley and Williams are detained pending trial. The remaining defendants are on bond pending trial. The parties estimate that the trial in this matter will last approximately 12 days. By this stipulation, defendants moved to continue the trial to the date May 4th, 2026. Yeah, that makes sense because you want all your stuff. Yeah, anyways, I'll hold off on that. I'm sorry. In the pretrial conference date to April 24th, 2026, this is the first request for a continuance. Defendants request the continuance based upon the following facts, which the parties believe demonstrate good cause to support the appropriate findings under the Speedy Trial Act. Defendants are charged with varying violations of 18 U.S.C. 1962D, racketeer influence and corrupt organizations conspiracy, 18 U.S.C. 1951A, conspiracy to interfere with commerce by robbery and extortion, interference with commerce by robbery and extortion, and attempted interference with commerce by extortion, 18 U.S.C. 2421A, transportation of an individual in interstate commerce with intent that individual engage in prostitution, 18 U.S.C. 1943, wire fraud, 18 U.S.C. 666A1A, embezzlement, conversion, and intentional misapplication of funds from organization receiving federal funds, 18 U.S.C. 13441, bank fraud, 26 U.S.C. 7201, attempt to evade and defeat the assessment and payment of income tax, and 26 U.S.C. 7203, willful failure to file a tax return. The government has produced over 60 gigabytes of discovery to the defense, including law enforcement reports, search warrants, and returns, criminal history documents, recordings, and photographs. The government is in the process of producing over 20,000 intercepted audio calls, as well as numerous surreptitious audio and video recordings, much of which will be protected. Discovery, meaning they're going to do what they did to Dirk. They're going to say, you can only see this stuff in front of your lawyer. You can't take it back with you. The government sent defense counsel a stipulation for a protective order. Yeah, see, that's exactly, I probably should have just read that one first and then told y'all. But that's basically what they're saying. While defense counsel for defendant Henley notes that defendant Henley objects to any continuances, meaning Big U like, let's get this out the way. Defense counsel represents that he is presently scheduled to be in the trials listed in the document attached to this filing as Exhibit A, as well as various other matters. Defense counsel for defendant Robinson is presently scheduled to be in the below described trials, as well as various other matters. So they're basically showing that the lawyer has a whole bunch of other stuff going on. So these are all the cases. We don't really care about that. I hate to say it that way, but these are basically other cases that he has going on, which is insane. But yeah. But this is what you do when you are a lawyer and you're trying to make sure that, one, you're doing your best, and two, that the government can't sit here and say, hey, bruh, we still gonna do this whether or not, because you are afforded the right to counsel. So yeah, continuous likelihood. God dang. Yeah, this lawyer is in a whole bunch of stuff. So all right. Yeah, so this is all you guys are seeing, basically, is that the lawyer has other cases that they had to deal with. And he has a lot. Holy hell. Yeah. So basically, he's showing that this is going to be his opening. Defense counsel for Hines is presently scheduled to be in various state court trials listed in the document. So yeah, bro, this is all they're saying, is that we need more time to do this because we already have prior obligation. Defendant Henley objects to continuing the trial in this matter. Nonetheless, the stipulating parties agree that pursuant to USC 3161H6, that the time period of May 20th, 2025 to May 4th, 2026 constitutes a reasonable period of delay for defendant Henley, who is joined for trial with a co-defendant as to whom the time for trial has not run and no motion for severance has been granted. So Big U, I have an idea on what he's trying to do, but Defendants believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. The government does not object to the continuance. Of course, y'all can't. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on the part of the attorneys for the government or the defense, or failure on the part of the attorney for the government to obtain available witnesses. For purpose of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that the time period of May 20th, 2025 to May 4th, 2026, inclusive, should be excluded pursuant to 18 U.S.C. 3161 H7A, H7B, I, and H7B4, because the delay results from a continuance granted by the court at defendant's request without government objection on the basis of the court finding that the ends of justice served by the continuance outweigh the best interests of the public and defendants in a speedy trial. Failure to grant the continuance would be likely to make a continuation of the proceeding impossible or result in a miscarriage of justice. And 3, failure to grant the continuance would reasonably deny defendants continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Nothing in the stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods be excluded from the period within which trial must commence. Moreover, the same provisions and or other provisions of the Speedy Trial Act may in the further authorize the exclusion of additional time periods from the period within which trial must commence. It is so stipulated, dated May 2nd, 2025. They had to grant it. This is everybody's attorney basically signing off. So, yeah. Now, I know people probably gonna react to the 20,000 calls and stuff like that and everything.
20,000 wiretaps. 20,000 times they said, hey, listen to that nigga. On top of what we already know. Goodness freaking gracious. Hey, Gary, it's early, bro. I can send you back home to your smoker mama. You feel me? You can get up out my classroom. It's easy call. It's early. You feel me? I'm just trying to wake and bake. Y'all my bad class anyway. You feel me? So I can send you back home to your smoker mama. She keeps sending you to school dusty. You musty. You feel me? I always got to feed you, bring an extra lunch because she can't afford to feed you. And a roach fell out your backpack the other day. I ain't tell nobody, but you know what I'm saying? Well, I'm good, bro. I'm good, bro. I'm pointing out. Didn't nobody ask you to point nothing out. This is sustained silent reading, Gary. Be quiet and listen. That's it. Be quiet and just read your book, bro. It's first period. It's first period, bro. It's way too early for this. It's way too early for this, bro. All right. You trying to get Gary out of trouble? You trying to save Gary? You trying to save Gary? Bro. It's not how we finna start today in my classroom, bro. It's not. So I was just pointing it out. Gary the kid that eat hot Cheetos. Gary the kid that eat hot Cheetos with a Dr. Pepper first thing in the morning. What's up with you, bro? Come on, bro. It's SSR. Just chill out. Go take that to ODM Slim class. You feel me?
Bruh.
Y'all don't do nothing in that nigga class no way. Y'all don't do nothing in ODM class no way. So y'all go take that. You know what I'm saying?
This is basically...
Okay. All right, Gary. All right. We're going to put you in timeout. Gary, go sit in the back of the class. Gary, go sit in the back of the class. And if you say something else, I'm going to put you out of my class. So, the timeout, we're going to start running this like a classroom. You feel me? We're going to start running this like a classroom. The timeout for 5 minutes, that's you going to the back of the class. When I ban you from the chat, you out my class. Wait. Take that back home to your smoker mama, bro. I don't deal with nobody bad kids. I don't even got bad kids. I didn't come to work to deal with somebody else's bad kids. You feel me?
What I believe is what they do when they pile it on. And no offense to Big U, I know he like, bro, I don't want to go to trial with these cats and anything. It's better to have a coterie of lawyers looking at the best way to fight all of this stuff. Now, granted, each lawyer will do his best for their client, not the whole group. I understand that. These lawyers have to be loyal to their client, not who the hell you think you are. Not who the hell is the main person. They don't care.
Now the best thing you could do is go separate yourself from the rest of the Wooty Bam. You feel me? Like that's the best thing you could. You're such a hater. You're such a hater. You're my biggest hater. I swear you're my biggest hater. She my biggest hater, y'all. You my biggest hater. Yes, you. Just 2 seconds. Just 2 seconds. Hater.
Care about that. They're not supposed to. They're not supposed to be working for Big U. They're supposed to be working for their clients. So in Big U's case, what I think he's thinking is, man, F all that. They're going to take what's best for them. These cats can flip on me. Now, some people can be sinister and say, well, Big U wants to go on with his trial first so he can throw everybody else under the bus. Well, if Big U does that, in my opinion, Big U is basically going to be giving credence to exactly what they've been saying. Who are they? They would be the government. If Big U decided to flip and say, yeah, this person did this person did that, how much time y'all think he really gonna get off? Like, to me,